all of it on paper because paper is so much more powerful than anything you could say in court. In court, you're going to be timid, afraid, scared. It's just natural. I mean, like I said, unless you're not afraid of going to jail. Like I'm not afraid. I'm a big, ugly guy. Well, I look like a biker, so I'm not afraid. Nobody's going to bother me. So they know I want to say what I'm going to say.
In other words, you put an answer into the court saying that what you said about is there any reason I can't have a jury trial? But if you're a defendant, you don't want to do it anyway, right?
Well, you've already explained it all in paper. There's no reason to say anything in court. I mean, you'd be crazy to go back on your paperwork because you'd novate every single thing that you submitted to the court. You could write 800 pages as soon as you open your mouth and you start talking to the judge other than saying, did you not understand the paperwork that's in front of you? Do you are not competent to lawfully or legally decipher what I said? Do you need help in understanding what I wrote? I thought I wrote it in plain, simple language. I used 2-syllable words. I made it as simple as possible. Where am I losing you?
So that's any court. That's criminal or civil?
Anytime you go before anybody like that, you always sure that you always give them a form of a question. You never take that question and give them back an answer. It's always in the form of a question. So if the judge asks you something, you say, you know what, that's a very good question. Let me write that down, and I'll get you back an answer in 72 hours. Is there anything else that you have a problem with deciphering anything on my paperwork? But never modify it there in court. You tell the judge, give me 72 hours and I'll get back to you on an answer with that.
On paper.
On paper. If that doesn't mean you got to go back in a cage for 72 hours, that's fine. I am going to do everything on freaking paper so nobody could say, I said this, he said this, because I'm trying to think of the word. Oh, the judges use, what's the word they use all the time? Oh, boy. I'll think of it in a little while. But what it basically says is if you try to appeal something, the judge always has this trump card to his appeal buddies. He's like, look, you didn't see the man's attitude in court. You didn't see what the man said to me. You didn't see he gave me the finger. You didn't say he stuck his tongue out at me. So no matter what this man wants you to rule for him on his appeal, you let my decisions. Oh, it's Ori Tennis. Oretenus. It's 2 words. Ori Tennis. You take my word on this, he'll tell his appeal judge buddies, fry this guy. And they'll fire you. And that's like a trump card that the judge could use no matter how magnificent your appeal is. He could tell his buddies upstairs, hey, this guy gave me the finger. Oh, he did? Oh, yeah, and then she stuck her tongue out at me. And then she fucking mooned me. So you're like, wait a second, I didn't do any of this nonsense. So you know what? The best thing to do is try to stay out of court and get in and out of there as fast as possible. Do it all in writing. The judge has a question for you. Say, that's a very good question, sir. You know what? I'm a little nervous right now. Can I please write that down, and I'll get back to you as fast as I can. Is 72 hours work? Is that fine? You know, will the court be happy with that? And just talk to them like that. Don't ever answer a question in court. The judge taught me that in Birmingham. He taught me that in old judge. He said, sir, I'm going to throw your case out in a half a heartbeat. Everything that you stylize had better come at me in the form of a question. So I said, what? Did you want me to play like Jeopardy with you? He said, exactly. If it ain't coming at me in the form of a question, I'm throwing your case out. So I was like, holy cow, how do I do this? And he put me on a spot. I said, thank God it wasn't for a lot of money, and it worked out all right. But a judge taught me that everything's got to be in the form of a question coming back to the court.
Did he say the reason?
Because who's got the authority? If I'm moving the matter, it's my case. I'm not answering to nobody. I'm the one, the Grand Inquisitor. I'm the one asking the court the question. I'm the one giving the other party the questions. I'm the one in authority.
So what he's saying that you, as the plaintiff, had to ask a question. You couldn't make a statement.
Right, as the prosecutor, right?
In other words, you were
I can't make
asking the defendant to answer.
Right. I can't make statements, and I can't answer. I got to only phrase everything to the other party in the form of a question if I'm prosecuting the case.
If you're prosecuting, but what if you're the defendant?
You're going to get slaughtered. I had told everybody in the last show, don't ever come in as a defendant. Somebody else said that. I'm trying to remember. Billy Thornton said that as well. He taught me that, and I just mastered it beautifully, where I take every single thing that they come after me with, and I automatically say, you're interfering with a right to blank, and you fill in a blank. You're interfering with my right to blank. That's my countersuit. But I don't say countersuit. I just say it's a whole new stand-up on its own independent cause of action suit. You're interfering with my right to a jury trial, period. I say, huh? Go ahead.
You're saying that I don't go into the court, back into the court as a defendant, just ignore everything and start my own suit?
Right. Billy Thornton did a great job. Like I said, what you do is you can answer theirs and say, I don't believe they have any authority to move me. I'm only here under, like, you can use fancy words like special appearance, only so that there's not a warrant out for my arrest, especially if it's civil. If it's civil, like I said in the Supreme Court rules, it's like simple rules, like Rule 101. Until all parties are ready to proceed in the civil matter, there could be no force or compelling of either of the party to perform. There's no reason for you to take the stage and act and carry out the court proceeding until you're ready. It's a simple law for civil proceeding. That's why it's called civilized. They can't make you dance if you don't want to dance. So that's a simple rule in civil proceedings. They can't force you to compel, to give testimony, to move your case, to defend your case, nothing. In civil court, you can just say, I'm just not ready. I want to stay the hearing. I want it held in abeyance until I'm ready. I got a headache, whatever. You can make up nonsense. You can say, I'm not ready.
So you're doing this just as to give you time to get your own case together?
Exactly. It's a stalling tactic. The same thing they do. It's a stalling tactic until they can build up a case. Marcia Clark should have done it against Trojan. They get a witness.
So I'm going to stall them, and then I'm going to do my own case. Can you walk us through the procedure for starting your own case? And
sure.
You say in a federal court, but you brought me to the site where it says that all state courts are common law courts. Why would you go to federalism as opposed to state?
Because, like, say me, I'm suing the governor, and all the judges in Alabama are Republican as well. The governor is Republican, and all the judges are voted. Even the Supreme Court justices in Alabama are voted in as, they're elected. So they're all Republicans. So how am I going to get somebody in a black robe who's not a Republican who's not going to side for the governor? It's diversity of citizenship, you could call it, but it's just a diversity of parties. They're in one state, I'm in another state. But you could say, what do you mean by state? It was like I'm in a natural state. I'm in a state of nature. I don't have to say I'm in the state of Virginia, because when people put me on a spot, it's like, oh, you're in the state of Virginia? It's like, what? You think I'm part of the dirt, the rocks, the gravel? I'm not in a state. That's ridiculous.
So what you're saying is that we're on the land and they're on the state, so we're foreign to one another.
So all I know is I'm in a natural state. I'm in a state of being. I'm a sentient being. I'm not in any state. Tomorrow you could change the map. I thought we were going to all secede from the United States tomorrow anyway. So I think they're going to change the name of Virginia anyway to Utopia Land. I don't know what they're going to call it tomorrow. I didn't write the rule. I don't play their name game. I don't play it. I just say, I'm a man. I'm aggrieved. I've been injured. That man did me wrong. He interfered in my rights. I want compensation. I want him to leave me alone. And that's my lawsuit. That's it, one page. When you read my lawsuit, it's like, holy Christmas. That's it?
Wait. So you're saying that all I have to do
give them a notice.
To invoke the court is to do that first page?
The first thing you got to do is...
That's on Angela's site?
The first thing you have
Can you walk us through this procedure?
Okay, this is what I tell everybody what to do. The first thing you do is write a letter, a cease and desist letter. Tell me, give them notice, you're interfering with right, blah, 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 blah. The right to association, the right to congregate, the right to carry a gun, the right to religious practice, right to whatever. The right to pick my nose and scratch my butt and be left alone while I'm doing it. Anything. You're interfering with my right to blank. You give a notice. You say, look, if you don't stop interfering with this right, or you stop interfering with giving me the right to go before a jury, you stop interfering with my right to have a common law proceeding, if you don't stop doing this, I'm going to charge you a fee. I'm going to charge you $1,000 a day until you stop interfering with this right. Not only do I believe I have this right, but the Constitution supports this right. Alabama Constitution, the New Jersey Constitution supports this right. State Code supports this right. State Supreme Court of New Jersey also believes that I have this right. So it's not only my belief. You know what? I'm going to come in with some good foundational evidence, backgrounds, proofs, and facts that my claim is standing on good foundation based on your freaking written law. So not only is it my belief, it's your belief. So that you can't anyone notice. You want to put all these citations in, that's where you do it. But you don't say, well, Alabama says I could do this in New Jersey. New Jersey doesn't say nothing. Tomorrow they're going to change the state to something else. They're pulling away from the United States. They're going to change it to whatever they want to change it to, Asbury Parkland, whatever they want to change it to. So you just use their old stuff.
Who's this letter to? The plaintiff?
The judge who's saying denying you the right to a jury trial. Who's ever doing you the wrong? Who's ever the wrongdoer? You say, hey, that's wrong. You can't do that to me. Stop that. That's the letter you give him. Hey, that's wrong. Don't do that to me. Stop that. Not only is that my belief, but the Constitution says this, the statutory code says this, the Supreme Court says this, the Bible says this, Ralph DeCabbage says this, McGill Gorilla says this. Everybody says this. You can't do me this way that you're doing me. Stop. If you don't stop, I'm going to charge you $1,000 a day. And I'm going to bring you before a jury. And if the jury finds that my belief is a good belief, they're going to give me the thumbs up like American Idol and go like, hey, we like your show and dance you just put on for us. You know what? Not only are we going to give you $1,000 a day, hell, we'll triple the damages. Yeah, that judge shouldn't have done that to you. Pay that nice lady, judge. That's how you do your notice. You notice a cease and desist. And then when they reach a cease and desist, if they just blow you off, you can say by tacit acquiescence, you can put that in a notice too. If you don't respond to this in 72 hours or 14 days or 21 days or 6 months, I'm going to say that you tacitly acquiesce to all the terms and conditions of this notice. And that you can do that. And then, like I said, if they still continuing to do this, say, well, I'm sorry that we couldn't settle this matter on a private side, but it looks like you've given me no choice, but I'm going to have to evoke my 9th article and 7th Amendment article rights under the Bill of Rights to invoke a common law jury trial against you.
How do you say that? In another letter?
Yep, just another letter. Let 3 days go by, 14 days go by, 21 days go by, 6 months, however long you wanted to let them go by. You could claim a wrongful act that somebody did to you 100 years ago. There is no statutory limitation. There is no latches that may be imputed to the public. If you bring up a statutory limitation and you're the prosecutor, then they could bring it up as a form of defense. Don't ever say 6 years went by, 2 years went by, 80 years went by. Don't ever bring up any of that nonsense. And if you drop dead and die, the Judicial Act of 1793, Section 31 says that your descendants could pick up your claim if you drop dead and die. Your children's children's children could pick up your claim because man can't be latched. The attorneys can. The Constitution latches the states to the federal government. They're all latched. They all took contracts. The judge took an oath of office. An oath of office is they bound themselves to the Constitution, or they bound themselves to certain duties and responsibilities. They bound themselves. They latched themselves. They have a contract to perform under. You don't. You can do whatever you want. You're unlimited. Your capacity to move and perform and do whatever you want is unlimited by any latches because you're a man. You're free to think. You're not a Frankenstein. You're not a creation of the state. You're not a monster.